behalf of Luthuli. Does the court please narrate the appearances of
Today is the day after a long period of time from the beginning of April 2025, of course, some intervals. A lot of evidence has been laid, but this judgment will be shortened as per agreement with the prosecution team. But the details of the evidence of a technical nature is annexed to the judgment of financial aid. This is a reopened inquest into the death of Chief Albert Luthuli, hereinafter referred to as Chief Luthuli. The prosecuting team comprises of Advocate Dina as the leader and chairman, Advocate Musimano, and Advocate Nobo, all of whom are from the NPA cluster. There is no opposing party. The late Chief Luthuli died on the 21st of July 1967. His death came as an unexpected blow to his now late wife, Nobel Luthuli, his children, the community of his village in Brazil, Scotland, previously known as Stenga, his comrades, the African National Congress in bracket ANC, of which he was a distinguished president, his religious affiliation, and the international community, amongst others. Chief Albert Luthuli's death was ascribed to an alleged goods train accident. The alleged train accident was reported to have occurred while Chief Albert Luthuli was crossing the Umbodi railway bridge in Jedo. The news of his death spread like wildfire across the country, across the continent, as well as internationally. It was generally known that the then South African government and the security cluster of the apartheid era monitoring every movement of his, having him banned from communicating or being in the company of more than the allowed number of people. Even on this fateful day of the 21st July 1967, Chief Luthuli was still under those banning orders. I'm sorry, I don't know whether it's deliberate that there should be an echo. There is an echo. I'll carry on, but maybe we need some adjustment.
it is the parties they are all attended. Mrs. Naledi, you may proceed on attending to the issue of the echo.
On the 19th of September 1967, a formal inquest, number 76 of 1967, was held at Stenga Magistrates Court, presided over by the resident magistrate, Mr. C.I. also, who happened also to be the one who was charged with the issuing of temporary payments to Chief Luthuli should the latter had necessity to travel out of Stema for his medical checkups in Devon. This 1967 inquest was preceded by a letter dated the 11th of September 1967, addressed by Boswell to the Secretary of Justice in Pretoria, in bracket, an executive arm of the apartheid government, advising the said secretary that the inquest would be held on the 19th September 1967. Footnote. The witness, Mr. Jeffrey Hathaway, who testified in this reopened inquest, described the said letter as an affront to the very principle of the doctrine of separation of powers, a subversion of justice and the rule of law. It did not end there, but Boswell went on to foretell that the outcome of the said inquest will be that Chief Luthuli's death was brought about by a train accident, and that the members of the Luthuli family would likely not accept the outcome. Boswell therefore knew that the conclusion of the inquest would be even before the formal inquest was held.
So, my lady, the echo emanates from a speaker that has been connected for the proceedings to be audible. It has no impact in terms of the recordings. Thank you.
As would have been expected, the train driver, Mr. Latapan, together with his crew consisting of the fireman, Mr. Crane, and the train conductor, Mr. Van Beek, were amongst the witnesses who submitted affidavits and who testified viva voce at the 1967 inquest. This is evidence that they were sure of what the outcome would be, exonerating them as employees of the South African Railway Department of any wrongdoing. Boswell's findings were, and I quote, the deceased died of a fractured skull, cerebral hemorrhage, and contusion of the brain, sustained by the deceased when he was struck by the goods train accidentally. Close quotes. As to whether the death came about by any act or omission on the part of any person, Boswell stated the following, and I quote, the evidence does not disclose any criminality on the part of any of the employees of the South African Railways or anyone else. Close quotes. The witnesses who were called to give viva voce evidence at the 1967 inquest were limited to the following. In respect of medical practitioners, the senior superintendent of the Stella Hospital, Dr. J.J. Van Zyl, a district surgeon. The other medical practitioner, Mr. M.J. Juliet, a neurosurgeon, was not called to testify, but submitted an affidavit which was then submitted to this court as Annexure C of the record. The affidavits of Drs. Ferguson and Dr. Van Zyl were submitted into the record of this inquest and accepted as emanating from the as Annex A and B. In respect of the police officers that testified in the 1967 inquest, was Detective Sergeant C.B.P. Lewis from the South African Rail Police, Devon, who calls investigating officer. The other police officer was Sergeant Andres P. Beldo, whose statement was submitted as Exhibit P in the 1967 inquest report. Further, there was the South African Railways employees, Mr. Latikan, the train driver, Mr. D.L. Fraley, the fireman on board the train, Mr. P.F. Family, the train conductor on board the train, and Mr. N. Matawa, a laborer of the South African Railways Administration. There were other witnesses who submitted affidavits which were accepted into the evidence, but who were not called to give revocable evidence. These included the wife of Chief Luthuli, Mrs. Luthuli, Mr. P.F. Papaya, the ambulance driver of Stenger Hospital, Mr. E.T. Tili, a bus range manager, Ms. E. Pega, an employee at Chief Albert Luthuli's General Dealer Store in Groundville, and Ms. Z, an employee of Chief Albert Luthuli at his sugar cane plantation. The family of Chief Luthuli was never satisfied with and never accepted the result of the 1967 inquest. They were never satisfied with the lack of an in-depth investigation into the circumstances of his death. Luthuli was never satisfied with and never accepted the result of the 1967.
To all small business owners, QuickBooks stands by you. Our everyday business is someone who chose the career.
Express their dissatisfaction in regard to the finding by Boswell, who presided over the 1967 inquest. To them, Chief Luthuli's death was a well-orchestrated plan to eliminate him. The same other interested parties approached the National Director of Public Prosecutions to have the death of Chief Luthuli inquest reopened. Pursuant to Section 17, capital letter A of the Inquest Act, number 58 of 1959 as amended, hereinafter referred to as the Act, the Minister of Justice, Honorable Mr. Ronald Lamola, directed the inquest should be reopened. On the 14th of April 2025, this court ordered that the inquest be reopened. As directed, after having satisfied itself that the jurisdictional facts exist for the inquest to be reopened, this inquest was then reopened. To remind ourselves with what inquest is, I will quote sections of the Inquest Act. This is designed to allay concerns of the general feeling why this inquest, why opening an inquest when nobody is going to be charged since they have died. We are mindful of the fact that in terms of the Act that regulates inquest and regulates reopened inquest, Section 17, capital A of the Act provides, I quote, the Minister may, on the recommendation of the Attorney General concerned, at any time after the determination of an inquest, and if it deems fit necessary in the interest of justice, request the Judge President of the Supreme Court to designate any judge to reopen the inquest. Whereupon the judge thus designated shall reopen such inquest. Subsection, an inquest referred to in subsection 1 shall, subject to the provisions of this Act, as far as possible, be continued and disposed by the judge designated on the existing record of the proceedings, and the provisions of Section 17, Section 2 shall, insofar as they are not contrary to the provisions of this section, shall apply mutatis mutandis to such inquest. As regards the recording of the findings and research in Section 17, capital letter A, subsection 3B, Section 16, subsection 2 and subsection 3 of the Act provides. Section 2, subsection 2, the judicial officer holding an inquest shall record a finding upon inquest to the identity of deceased, as to the cause or likely cause of death, as to the date of death, and as to whether the death was brought about by any act or omission prima facie involving or amounting to an offense on the part of any person. Subsection 3 reads, if the judicial officer is unable to record any finding, he shall record that fact. An inquest is an inquisitorial investigation process driven by the presiding officer. The state's contention right at the outset was that the finding should be made by this court, which differs from the finding made by the 1967 Inquest Court under case number 76 of 1967. The state then evidence by several retention that Chief Luthuli was murdered, and that those responsible for his murder, alternatively culpable homicide, and a crime against humanity in contravention of the relevant customary international law and Section 2 of the Constitution of South Africa, Act 108 of 1996, should be held liable by direct conduct vicariously or vicariously liable as authorities in charge of this reopened inquest, where firstly, whether there exists evidence which was not presented before the initial inquest number 76 of 1967, necessitating that this court makes a fresh finding in terms of Section 17, capital letter A, subsection 3, read with Section 16, subsection 2 of the Act. Secondly, to determine whether the proceedings conformed with the prescriptions of the Act in ensuring that a thorough investigation into the circumstances around the death of Chief Luthuli was made by the 76 of. Thirdly, whether that court was presented with sufficient evidence to make credible prima facie findings in terms of Section 16, subsection 2. In looking at above mentioned issues, the court is reminded of what was stated in the case of Timor, magistrate of Johannesburg, 1972, 281 T, 287 to 288A. I quote, were echoed by Seeley, JP, and Murray, J. And I quote, for the administration of justice to be complete and to instill confidence, it is necessary that, amongst other things, there should be an official investigation in every situation where a person has died of unnatural causes, and the result of such investigation should be made known. Therefore, the Inquest Act provides that if there is reason to believe that the death has occurred, that such death was not due to natural causes, and that it was not followed by the institution of criminal proceedings, there shall be an inquest as to the circumstances of the death, close quotes. Therefore, the inquest must promote public confidence, as it was held the art as Tylee, where it was held that, and I quote, the underlying purpose of an inquest is to promote public confidence and satisfaction, to reassure the public that the deaths from unknown causes will receive proper attention and investigation, so that, where necessary, appropriate measures can be taken to prevent similar occurrences. And so the persons responsible may, as far as brought to justice. In the state seeks an order which, in my view, is justified by the voluminous evidence that has been presented before me by various witnesses, whose details are listed in paragraph 12 below. The order sought may be summarized as consisting of 3 parts. Namely, 1, that the fine Boswell, dated September 1967, at the Stenger Magistrates Court under Inquest number 76 of 1967, is set aside. Number 2, that the finding pursuant to section 16, subsection 2C be made. That a finding in subsection 2D of the Act be made. Closing argument was presented to justify and to convince this court, indeed, there is abundant evidence to justify the granting of the order sought. This judgment incorporates such closing argument without singling it separately, especially as there is no counter-argument for this court to find otherwise. I must express my gratitude and acknowledgement of the state by the prosecuting team of painstakingly presenting this case for me. I shall now deal with a brief summary of the evidence presented. Mutual agreement with the prosecuting team cannot deal with the detailed evidence of all the witnesses who testified. The evidence tendered at this reopened inquest included oral and documentary evidence of 3 investigating officers who were assigned to investigate this matter from 2021 under the TRC/Public Era Crimes Unit. Witnesses in the persons of Captain G.F. Kamanyane, Madimetsa J.A. They traced the whereabouts of the 1967 personnel, doctors and police officers involved in the initial inquest. Lieutenant Stein further traced the whereabouts of other potential eyewitnesses, with the last notable one being Mbemu Nyandu. Who had been sent by his father Nyandu to deliver a letter to Chief Luthuli on the 21st of July 1967, only to witness him, that is Chief, being assaulted by men from the train which was stationary in the vicinity. In bracket, much about this will be said later. He made reference to Exhibit B, C, DD, and FF, as well as FF1. Secondly, there was oral and documentary evidence of a representative of the African National Congress, the ANC. Chief Luthuli was President General, Chief Luthuli's deputy. It was presented by Mr. Jeffrey Tamsan, a high-ranking member of the ANC, who gave evidence from a political perspective detailing the political life of Chief Albert Luthuli. He outlined the political motive behind the killing of Chief Luthuli, dispelling the notion of a train accident. Mr. Khatebe testified about the role that Chief Luthuli played in developing, guiding, and reshaping the thought of those who were oppressed by the apartheid regime. How Chief Luthuli advocated and fought for the emancipation of the black oppressed people of South Africa. How he pushed for the gradual shift from struggle, despite the media portraying him as a passive lame duck who was under the apartheid government oppression. Mr. Khatebe further enlightened the public about how Chief Luthuli was voted as the President General of the ANC in the presence and attendance of leaders such as Nelson Mandela, Walter Sisulu, Inter Alia, who all grew under the stewardship of Chief Luthuli, reporting to him on all underground operations pertaining to the ANC, even after it was banned in 1960. He further gave an overview of the struggled credentials of Chinese involvement in formation such as the Natal Indian Congress of the Democrats, the Current Congress, and others, was held, out of which the Freedom Charter was born. Truly advocated against forced removals of black people from places like Sophia Town, Ketomena, and Mkumbane, to name but a few. Banning orders were the order of the day, culminating in a number of people living under banning orders at specific times. This became even more evident in 1966 when the American Senator Robert Kennedy visited Groundville. Chief Luthuli, however, could not speak to him of other people. Soon after this, that is the period of the visit in 1966, that in 1967, Luthuli was assassinated by forces of the apartheid regime as a goods train accident. Mr. Hadaway cited extracts from books in the likes of Comrade the Commander, The Life and Times of Joe Modise, in reference to meetings held in the sugarcane fields chaired by Chief Luthuli in 1962. He further referred to the book titled, by Chief Albert Luthuli titled, Let My People Go, symbolizing the hardship and pain Chief Luthuli was going through, for which he paid the ultimate price of death. Chief Luthuli was regarded by the apartheid era government as a slippery irritation whom they wanted to get rid of. Mr. Hadaway highlighted the animosity of the then apartheid government, which was displayed when Chief Luthuli the Nobel Peace Prize in 1961. Thirdly, oral evidence by and persons associated with Chief Luthuli and his family, and this included the following: Mrs. Veremina May Luthuli, affectionately known as Veni, the daughter-in-law of Chief Albert Luthuli. Mr. Luthuli Albert Luthuli, the first male grandson and eldest of the Luthuli grandsons. Dr. Albertina Nomatuli Luthuli, currently aged about 93 years old, who is the daughter of Chief Albert Luthuli and who was a qualified medical doctor at the time of Chief Luthuli's death. The evidence of these close family members was to demonstrate that Chief Luthuli was fit and healthy, was not hard of hearing as supposed by the witnesses of the apartheid regime, and that his sight was not impaired such that he would not have seen the oncoming train. His hearing was also not so impaired that he would not even hear a whistle or the sound of the train as it passed over the Umbodi River Bridge. According to the family members, Chief Albert Luthuli had been able to see the oncoming train and thus avoid colliding with it. They dispelled the notion of the train accident as the cause of the demise of Luthuli. Through the use of photos, extracted archives, Dr. Albertina Luthuli testified that her father, Chief Luthuli, was complete and not when he was buried. The clothes he wore on the 21st of July 1912 about the visit by Senator Kennedy in 1966, echoing Mr. Hadaway's sentiments. Make matters worse, heightening the negativity and culminating in Chief Luthuli's assassination in 1967. She further testified that even after Chief Luthuli's death, they continued to suffer and be subjected to harassment, to the extent that in the year 1970, she and her husband, Dr. Ngakane, who was also under banning orders, together with their children, went into exile, only to return to the Republic of South Africa in 1991. It was only after her return that she followed up the matter and eventually got hold of a copy of a post-mortem report compiled by Dr. Van Zyl, that is Exhibit D, from Stena Hospital. As a qualified medical practitioner, she raised alarms about the glaring shortcomings and inconsistencies in the report. To the best of her knowledge, no family member was called upon to present and give evidence at the 1967 inquest hearing, despite that they were still resident in state. The other witness from the family and close associates was Mr. Abigail Luthuli, born Mabaso. She is aged 67 years, and as well as Emma Numalo, aged 89 years. They testified about Chief Luthuli as an individual outside of his family setting, there and then providing this court with a perspective of how highly Chief Luthuli was regarded in the community of Groundville. They also echoed the sentiments expressed underground activities. Child of such community, as she never got to know the contents and was under strict not to open the bag containing letters to and from Chief Luthuli. Mr. Numalo testified that during the 1960s, even talking about or mentioning the name Chief Luthuli was taboo, as it would attract trouble with the police. She testified that on the afternoon of Mr. Numalo testified that on the afternoon of the incident, 21 July 1967, he accompanied Mr. Mabaso, the father to Mrs. Ntomo, to the scene at the Umvoti train bridge, where they cleared the ship. A witness in the name of Stanley Chusi testified that he is employed at the Luthuli Museum, which is situated at the former home of Chief Luthuli. He gave interviews and pointed out valuable points to a photographer from the local criminal record center, commonly known as the LCRC. That photographer was Constable Luthuli, and to Warrant Officer Regis, the forensic reconstruction unit attached to the SAPS in Pretoria. This has been confirmed by Warrant Officer Regis in his exhibit F. These points pertain to the daily or regular routes that Chief Luthuli walked from his home to his shop in Guaranque and to his cane fields, including the walk over the Umvoti railway bridge. He referred to a steel bridge running over Nchawini River near Gledo, and said this is similar to the old Umvoti River Bridge, which was subsequently demolished after the death of Chief Luthuli. He further, at a later stage in the proceedings, testified in respect of the photographs of the procession at Chief Luthuli's funeral. With reference to these photographs, it was clear that the body of Chief Luthuli was intact and not dismembered, and as he lay in his coffin, it was a complete body. unlike the situation where a person who's not by a train would have his body dismembered. Mr. Brian Kaba testified with reference to his affidavit Exhibit O and told this court that the 90s were loaded with his assist, and these were handed to Captain Amanya. The duplicates of these documents are kept at the Luthuli Museum in Brazil. There was also oral evidence of Mr. Mohammed Hanif Manju, who was present as an admission clerk at the Stema Hospital when Chief Luthuli was wheeled in, lying in a stretcher on the 21st of July 1967 at about 11:30 in the morning. He knew Chief Luthuli very well since about 1959, when he was a young boy of the Manju family. He frequently drove Chief Luthuli back to his home after the latter had been with his father. His father was Mr. E.V. Mohammed, a bookkeeper and friend of Chief Luthuli. His evidence is that on the 21st of July 1967, whilst on duty, he received a phone call from the station master of Gledo railway station requesting an ambulance to be sent to the station for a native who had been knocked by the train. His recollection is that it was a Sexuani who was dispatched to drive the ambulance and not Pakot's reveal. When Zwane came back into the outpatient unit, Manju immediately recognized Chief Luthuli as the patient who was being wheeled in. Chief Luthuli was unconscious. Manju did not see any bruising or bleeding on the face or on the head. However, he considered that if there was bleeding at the back of the head, he would not have seen it. In due course, Chief Luthuli was taken into the examination room, and one Dr. Mizra, a district surgeon, was called to attend to the injured Chief Luthuli. Dr. Gregerson, the senior superintendent, was also in attendance. Manju found this strange that Dr. Gregerson, as senior superintendent, was not expected to attend to patients, especially black patients. Another documentary and oral evidence was presented by expert witnesses, namely Warrant Officer B.C. Bejes, Warrant Officer Sunet Nel, Mr. Gert Willem van Tonder, Mr. Leslie Labuskaghni, Dr. Sibusiso Nsele. Coincidentally, Dr. Nsele is from Chief Albert Luthuli Hospital in Durban. It is tried that an occurrence of a train or a motor vehicle accident, for that matter, or an aeroplane, requires evidence of a technical, forensic, and pathological nature to be led to prove, firstly, that there was such an accident, and secondly, its probable cause. In this reopened inquest, evidence was led of 2 train experts, evidence of a reconstruction expert, evidence of a simulation expert, and a specialist forensic pathologist. It would be remembered that no such expert evidence was adduced in the 1967 inquest. The expert witnesses that were called at this reopened inquest had the mammoth turning if a train accident did indeed, whether the injuries found on the body of Chief Luthuli were consistent with those of a train accident. The official who was assigned to reconstruct the alleged train accident is Warrant Officer Burgess. That is, after attempts to engage private reconstruction expert failed. Warrant Officer Burgess gathered information from Mr. Labuskaghne and Mr. Van Tonder, who are trained experts. For purposes of simulation, he used Warrant Officer Sunette Nell, who happened to be of the same height and weight as Chief Luthuli. For the forensic analysis of the post-mortem report, he engaged the services of Dr. Nzele. I propose that we take a break at this juncture and resume at 11:30. Sorry, I can't get out of this bench. Can we sit again? Sorry. Quarter jeans.
This too.
all came to one conclusion. Suffice to say that Dr. Ntsele, with reference to his report, which is marked Exhibit Y of the record, evaluated the post-mortem report compiled by Dr. Francis in 1967 and noted the following. 1. That the injuries indicated on the said post-mortem report do not resonate with the injuries that would have been expected from a pedestrian involved in a train accident. 2. That generally, a person who was struck by a train would sustain multiple fractures on different regions of the body. 3. That generally, a person struck by a train would sustain multiple abrasions, bruises, and or lacerations. 4. That the injuries recorded on the face of the post-mortem report are grouped without providing specific distinctive details about the injuries in relation to wound measurements and specific locations within the anatomical sites. 5. That it is not revealed how many and how big the skull lacerations and bruises were. 6. That there was insufficient description related to the extent and severity of the fractures sustained by Chief Luthuli. 7. That there was no diagrammatic description of the location of the injuries on the body of Chief Luthuli. 8. That there was no documentation of the clothing of the deceased, and therefore it was not possible to obtain cues, the presence of the debris, like grass and or soil or sand, which would give an idea as to where the person could have been and where he was hidden. Number 9, the post-mortem examination was so hurried that it was conducted 90 minutes after the death and while the body was still warm. There was no cultural or religious reasons necessitating the examination to be done so soon after the death, even before rigor mortis had completed. Number 10, with reference to Dr. Gregerson's evidence in the 1967 inquest, Dr. Ntsele observed that the X-ray records were omitted. This was done deliberately to conceal vital evidence of the actual injuries. Also, with reference to Dr. Gregerson's evidence in the 1967 inquest, Dr. Ntsele observed that Dr. Gregerson omitted to state whether the fracture on the left elbow was simple or a complicated one. Had this been detailed, then it would have been possible to ascertain the amount of blood force which could have contributed to this fracture. Further, that given the distribution and nature of the injuries, one would have expected the clothing to be full of blood. However, Dr. Gregerson had noted that there were no signs of drinking on the body, but that the clothes were torn and dirty. And lastly, as far as Dr. Gregerson is concerned, Dr. Ntsele noted that there was no physical evidence to suggest that Chief Luthuli was thrown some distance away on impact. Yet Dr. Gregerson conformed to the conclusion reached by the evidence leader in the 1967 inquest that Chief Luthuli was thrown away some distance on impact. And as far as Dr. Luthuli is concerned, Dr. Zele made the following observations: that Dr. Hubert's conclusion that Chief Luthuli died as a result of head injuries as well as chest injuries does not make sense. This for the reason that Dr. Hubert, on the other hand, concluded that, and I quote, it was not possible to determine whether there was an associated pneumothorax. Further, that the quality of the medical attention given to Chief Luthuli is riddled with a number of omissions. These omissions include, for instance, the failure to immediately transfer Chief Luthuli to King Edward Hospital in Devon, but instead to detain him for close to 2 hours at Staying Hospital, which was not properly equipped to treat patients with head injuries who needed neurosurgery intervention. After a careful analysis of the injuries sustained by Chief Luthuli, including the final condition of his body and clothing, Dr. Zele was of the opinion that Chief Luthuli was assaulted and died as a result thereof on the same date, being 21 July 1967. His conclusion is as follows, and I quote, the presence of bruises on the dorsal aspect of both the left and the right hands, as well as the fracture on the left proximal ulnar bone, may signal defense injuries, which would normally occur when a victim of assault instinctively raises his hands and arms to protect his eyes, face, or head. Close quotes. Now, I have as Annexure A detailed analysis of the evidence presented by the experts in the name of Warrant Officer Sunil, Warrant Officer Pages, Mr. Labus Kahni, and Mr. Pantoga. The analysis of technical evidence presented at the initial inquest held on the 19th of September 1967 compared to the current reopened inquest, which commenced on the 14th April 2025. It is pertinent to provide the analysis of technical evidence presented at the initial inquest and find comparison. Through this analysis, this court was persuaded to overturn the 1967 inquest with respect to the death of Chief Luthuli. The overturning of that rule would amount to a just verdict with respect to the circumstances which led to the death of Chief Luthuli. The evidence that was presented before this court sets out and the details as provided by trained experts, the reconstruction and simulation experts, as well as the medical experts in the name of Dr. Nzele, which I've just gone through. In the simulation evidence, it was demonstrated that the locomotive, similar to the one that supposedly knocked down Chief Luthuli, would be it wasn't there. There wasn't any accident, according to the simulation expert. It was demonstrated here in quantum video, and we watched how Daphne demonstrated the train, which is exactly the same, save for the train number to that of the 1967 locomotive. There were also inconsistencies and improbabilities in how the guard, after the train had stopped, had to go and protect the train. It was also not clear from the evidence of 1967 how a train master would allow the train to proceed with its journey to Devon instead of the area and regard it as an accident scene and have police officers immediately investigate forensically what could have happened. The drawings that were provided by Detective Sergeant Lewis in the 1967 inquest were also criticized in the sense that they make no sense. It is only through the reconstruction experts that one would get a picture which ultimately shows that there wasn't any investigation. There wouldn't have been any investigation since the train had already left for Devon. So it would have been difficult to see exactly whether the train stopped at a particular point as Latihan said. For the sake of interest, the detail of the expert evidence was an analysis of the different evidence presented by Lewis and Berger compared to the evidence presented by witnesses in this reopened inquest was ably compiled by Advocate Cheney and comprises several pages. It will be attached to this judgment as Annex A. The other vital links of eyewitnesses is as follows. As a result of the reopened inquest being widely publicized through the media platforms, witnesses started coming forward. One Mr. Bafili Heche, aged 70 years, came forward to testify as follows. He became aware of what actually befell Chief Luthuli on the fateful day of the 21st of July 1967 through what the late Portfolio Barnabas Minyanu, who died 5 years ago, around 2019 or 2020, related to him. Mthetje's affidavit was subsequently taken down in writing by the investigating officer, Lieutenant Colonel Stein, and has been accepted into the record as Exhibit AA. The late Portfolio Minyanu was the son of the late Thomas Minyanu, an Induna in Genezano area in Lamesi, KZN. At that time, the black people were involved in an ongoing land claim dispute, which is still going on to this day. Mthetje was in due course earmarked to take over as chairperson of the Land Claims Committee. It was during the process of the takeover, during 2015, that the elderly Potwayo Nyano shared with him the vital information. This information had been related to him by Thomas Nyano, as I've said, about the eyewitness who observed Chief Luthuli being assaulted by white men from the train that was stationary at the Umbodi River Bridge on the 21st of July 1967. This eyewitness was the younger brother of the late Potwayo Nyano. It later turned out during this reopened inquest that the name of this younger Nyano was Mbemo Nyano, as per information obtained by the investigating officer, Lieutenant Colonel Stein, from an elderly lady, Mrs. Naide, who is now aged 84 years, on 25 June 2025. The said Mbemo Nyano had possibly witnessed the incident of assault of Chief Luthuli when he had been sent to deliver a letter to him at his home in Groundville, only to be directed to the cane fields where Chief Luthuli was supposed to have gone. Mbemo rode his bicycle and purported to go to the cane fields to deliver the letter. Fortuitously, he saw Chief Luthuli being assaulted with a shovel by the train occupants, the train workers that had been from the goods train. When the assailants realized that they were being watched, one of them gave chase to Mbemo, who fled the scene in his bicycle. One can conclude that the assailants were disturbed and could not complete their assault on Chief Luthuli. To this day, we can only draw inferences that Chief Luthuli would have died at that particular point with all the evidence being hidden forever. It is clear when one considers the simulation experts' evidence as to how a person who is not by train would have all the parts of his body dismembered to the point of not being recognizable. We can only have various scenarios. There is the notion that Latican tried to make Chief Luthuli lie in a more comfortable position. Actually, would mean that they tried to drag him onto the rail lines and they were not caught them in the act. A few days after the 21st of July, 1967, police officers from either Tobat or Verulam police station came to the Nyando homestead to look for Mbemo Nyando, and eventually they got him. They took him away under the pretext that they were going to take a witness statement from him. To this day, the said Mbemo Nyando has never returned home. Luckily for the Luthuli family, for the African National Congress, for the comrades, for the international world, this gives a glimpse of what actually happened to Chief Luthuli. Even if Mbemo, unfortunately, is never found, and in all probabilities, he is presumed dead. But the truth, it always has a way of coming up. Mr. Sibongile Elizabeth Ndimande born Mnyandi also echoed the sentiments expressed by Mdletshe about the activities of her grandfather Thomas Mnyandi, as well as the disappearance of Mbemu Mnyandi. This event about Mbemu's disappearance became one of those topics that are never spoken about in the family gatherings for fear of negative repercussions. The impact of Chief Luthuli's death still looms large amongst his family as well as amongst the public in general. Mrs. Lindiwe Nanangobese Mngwayo read into the record the victim impact report, which was accepted as Exhibit CC, which had been crafted by her for the living grandchildren of Chief Luthuli. The report detailed the impact that Chief Luthuli Luthuli's death had on his family. It is evident from the reading of the said report that the entire family still feels a lot of pain. Had proper prosecution been done in 1967, the family would have been vindicated in seeing those responsible for Chief Luthuli's death being brought before appropriate criminal courts. Chief Luthuli had a number of grandchildren, and I shall deal mainly with those referred to in the report submitted by Mrs. Lindiwe Nanangobese Khumalo. Firstly, the Ngakane children, born of Dr. Albert Luthuli and Dr. Pascal Ngakane, feel that they were forced to live in exile as a result of the actions of the killers of Chief Luthuli and the institutions associated with those killers. Secondly, the Kabashi grandchildren have suffered far-reaching effects and fear. Thirdly, the Ngobese grandchildren, their mother is the author of the aforesaid report, Exhibit CC, painfully reflected on their grandfather and how he suffered to his death. They equate any attempt to erase Luthuli's death to actually erasing it from the history of Africans at large. I must add that today we have several government buildings, roads, and other institutions named after Chief Luthuli, in almost every big city, to demonstrate how difficult it is to erase the legacy of Chief Luthuli. Christian and Cynthia also separately echoed the sentiments of loss. Fifthly, the children of Wilhelmina and Edgar Luthuli were also seriously affected. We saw and heard Chief Albert Luthuli testifying before this reopened inquest. His demeanor demonstrated that he still feels heavy pain as a result of the loss. My final evaluation is as follows. Over and above what has been said above, in assessing the evidence presented to this court in the reopened inquest, I bear in mind that the standard of proof is not as stringent as in the criminal case, in respect of which the test is proof beyond any reasonable doubt. Nor is it the standard of proof on a balance of probabilities, as is the case in civil trials. In the decision in Re Boniwe and others, 1994, Volume 2, SACR 425-SE, at 427B, Zitman JP, dealing with the standard of proof required for a positive finding to be made in terms of section 16, subsection 2, subsection D of the Act, said the following, and I quote, an inquest is held where it appears that the death has occurred, that such death was not due to natural causes, and where criminal proceedings have not been instituted in connection with the death. In the case of the RNO versus Chile, 1990, volume 2, SA 899, bracket A, small brother JN, stated at 901 into G as follows, quote, the function of an inquest is to determine the identity of the deceased person, the cause of death, the date of death, and whether the death was brought about by any act or omission involving or amounting to an offense on the part of any person, whether the sorry, let me read it again. The function of an inquest is to determine the identity of the deceased person, the cause of death, the date of death, and whether the death was brought about by any act or omission involving or amounting to an offense on the part of any person. In terms of section 16, subsection 2, this determination would include, insofar as possible, a finding as to who the responsible offender or offenders are. The underlying purpose of an inquest is to promote public confidence and satisfaction, to ensure the public that all deaths from unnatural causes will receive proper attention and investigation, so that, when necessary, appropriate measures can be taken to prevent similar occurrences, and so that the person responsible for such events may, as far as possible, be brought to justice. I've already referred to the decision in Timor and Another, as well as to the RNO versus magistrate, Cape Town, where Van der J stated that, in open quotes, an inquest is not aimed at proving anyone's guilt, but is most certainly aimed at ensuring that, if possible, where guilt exists, it will not remain hidden. Close quotes. The above quoted decisions, amongst many others, mean that even where those who are found to be responsible for the death of a person are known, and their identity in some form should never remain hidden forever. In this matter before us, all the culprits have since died, as Lieutenant Colonel Stain has testified and submitted affidavits to that effect. Letterman could not be found. Training has died. Dr. Peterson has died. Dr. Van Zee has died. They all have died. And unfortunately, their death was years after 1967. They could have been found, we could be seeing them today. But, well, who have died. An in-depth analysis of the technical evidence presented at the 1967 inquest and of the analysis of the reopened 2025 inquest has been done through the evidence of trained experts, as I've said, the simulation experts as well as medical experts. It shows one thing, this in-depth analysis, that the 1967 inquest is riddled with lies and inconsistencies. The persons of authority, from the presiding magistrate also to the medical personnel and the police officers in the person of Detective Sergeant Berger and Lewis, and the South African Railways laborers, including the train driver, the fireman, the conductor, and Mataba, were all hell-bent to cover up the circumstances leading to the death of Chief Luthuli and to present false evidence that Chief Luthuli was struck by a goods train. Dr. Nsele, as I have highlighted above, in his evidence before this reopened inquest, testified about the discrepancies in the evidence of the three medical practitioners involved in the 1967 inquest. The police officials, Berger and Lewis, have also been shown to have not done proper preservation of the scene of the so-called train accident. This shows that there was no train accident. Also concerning is that the Glencoe station master, Mr. Pretorius, would allow Lateran, Crailing, and Van Wyk to proceed with their journey in the goods train in Durban, despite the so-called train accident. This was done even before the injured Chief Luthuli was removed by ambulance to hospital. The railway laborer, Ntsakani Mataba, who said he was working on a new bridge that was constructed nearby, told the 1967 inquest that the whistle of the train was not blown. And he later considered that it could have been blown, but he was prevented by the strong wind blowing from the southwesterly direction. There was no blowing of the whistle. Regard being had to the contradictory evidence of the train driver, Lateran, Crailing, the fireman, and Van Wyk, the conductor. There are also timeline discrepancies between the evidence of all the rail employees involved. If one compares that to the evidence of the ambulance driver, Papaya, they mention different times to the extent that one would think that they are talking about different events of a different date. The 1967 inquest proceedings were flawed. The court in 1967 failed to thoroughly evaluate the evidence presented by the persons at the scene and to compare it with the conflicting evidence of the witnesses who were not present at the scene, like Mrs. Mfega, Mrs. Zipi Gumede, and the so-called grandchild of Chief Luthuli, L3, who turned out not to be known to the family. At the end of the day, reading of the 1967 inquest records reveals that Chief Luthuli was not provided with the much-needed emergency medical care. Instead, a neurosurgeon was called from Durban to travel to Stenger Stella being a hospital, which I must say, it is public knowledge that is not fully equipped for most of the medical needs of the people around Stella. The evidence of expert witnesses who testified in this reopened inquest shows that all these experts are competent experts, and they are competent to express their particular opinion. They all have personal knowledge of the topics they testify on and have experience on their respective topics. They relied on the knowledge and experience of other acceptable experts in their respective fields. They demonstrated that they have grounds upon which they base their opinions. In short, they met all the requirements as expounded in the case of Monday versus Protea Insurance, 1976, Volume 1, Essay 565, bracket EC. It is true from the evidence adduced in this reopened inquest that, as Advocate Msimano submitted, there was, and perhaps even currently, an entrenched culture of lying about the true facts where the murder of a political activist is involved, and that apartheid was institutionalized, with law being the primary tool used to give effect to apartheid. We consider here actions of the medical practitioners that I have mentioned, who were stationed at Stema Hospital, and those of Dr. Ubed, a neurosurgeon stationed at Wentworth and King Edward Hospital. In isiZulu, I would say, and these are my own words, wafika eStema Hospital wazombhede. We consider also that even magistrates in the law courts use the law to push clandestine agenda. Consider the actions of Mr. Oswald. Mr. Advocate Msimano further referred to the cases of Griffiths Mqayi, Mr. Hafaji, Mr. Chimo, Mr. Imam Harun, to name but a few. Mr. Msimano further submitted that in this case we are dealing with here, there was careful planning that involved even demolishing the Mvoti River Bridge and constructing a similar bridge over Jawini River. The aim was only to get rid of the evidence even for yet later years, because as we sit here today, we cannot do an inspection in local on the Mvoti River Bridge because it's no more there, it's lying in ruins. Advocate Nobel gave us an international law perspective, rehashing that it was in 1966, a year of specific resolution of the United Nations General Assembly, that Chief Luthuli was visited by Senator Robert Kennedy, gravely concerned at the intensification of the policies of apartheid in South Africa. The General Assembly noted with concern and expressly condemned what was happening in South Africa. They were saying that apartheid was a crime against human Chief Luthuli was subjected to such crime against humanity. Mr. Noble echoed the sentiments expressed by Advocate Junior, the leading prosecutor, who referred me to the most recent decision in the state of versus Peace Prize and two others. It's an unreported decision, it's a 2025 decision of the Gauteng Division of the High Court, dated 14 April 2025. When he said those responsible for murder, alternatively culpable homicide, and crime against humanity in contravention of the relevant customary international law and Section 233 of the Constitution should be held liable by direct conduct or vicariously liable as authorities in charge of those who executed these crimes. Advocate Noble further referred me to the article by Professor John Deeper in alluding to the fact that apartheid was officially criminalized in 1973 as a crime against humanity, and that inhuman acts resulting from the policies and practices of apartheid and similar policies and practices of racial segregation and discrimination are international crimes. The Apartheid Convention refers directly to the South African circumstances. The persecutors of Chief Albert Luthuli, as well as other persons opposed to apartheid, therefore amount to crime against humanity, and so does this murder of Chief Albert Luthuli. Advocate Junior, in closing, submitted that the evidence presented is sufficient for this court to set aside the findings of the 1967 inquest and to substitute same with the finding which I shall make in due course. From the body of the evidence adduced before me, this court can be accepted that there exists evidence which was not presented before the 1967 inquest, which necessitates that this court makes a fresh finding in terms of section 17, capital letter A, subsection 3, read with section 16, subsection 2 of the Act. That there was no thorough investigation into the circumstances around the death of Chief Luthuli. And that their court in 1967 was not presented with sufficient evidence to make a credible prima facie finding in terms of section 16, subsection 2 of the Act. Having considered all the evidence, including expert evidence, which was very valuable to this court, and I must say that the evidence presented by experts before this court corroborates what the Birmingham saw. He is not here to testify, but what he relayed to the Nyari family is corroborated by all the experts that testified before this court. I therefore give the following order. 1. Part A. The finding and the ruling of the magistrate, Mr. C.I. Oswald, dated 19 September 1967, at the Stena Magistrates Court under Inquest number 76 of 1967 is set aside. B, in terms of section 17, capital letter A, subsection 3, read with section 16, subsection 2 of the Inquest Act 58 of 1959 as amended, the following orders are made. Roman figure 1, in terms of section 16, subsection 2A, the deceased is Chief Albert John Luthuli, an African male and the president of the African National Congress. Roman figure 2, in terms of section 16, subsection 2B, as to the cause or likely cause of death, it is found that the deceased died as a result of a fractured skull, cerebral hemorrhage, and contusion of the brain associated with an assault. Roman figure 3, in terms of section 16, subsection 2C, as to the date of death, it is found that the date and time of death is approximately 14:25 p.m. on Friday, the 21st July 1967. Order number 2. In terms of section 16, subsection 2D, as to whether the death was brought about by any act or omission prima facie involving or amounting to an offense on the part of any person, which is found as follows. 2.1, that the death is attributable to cumulative acts and omissions of the following. 1, assault by members of the security special branch of the South African police acting in concert and in common purpose with employees of the South African Railway Company. 2, that the following persons committed the crimes or offenses of defeating the ends of justice, perjury, and being accessories after the fact to the crime of murder. The persons are as follows. Mr. Albertus Stephanus Letterhan, the locomotive driver, whose whereabouts cannot be ascertained. B, Mr. Daniel Lesen Crane, the fireman, whose whereabouts cannot be ascertained. C, Mr. Peter Francois Van Beek, the train guard, whose whereabouts cannot be ascertained. D, Detective Sergeant Agnes Petrus Berger, Railway Police Officer from Stenger, whose whereabouts cannot be ascertained. E, Detective Sergeant Charles Baron Petrus Lewis, Railway Police Station from Devon, whose whereabouts cannot be ascertained. Andres L.H. Pretorius, Railway Station Master, whose whereabouts cannot be ascertained. Mr. Stein of the Railway Station Foreman, whose whereabouts cannot be ascertained. And the members of the South African police who are alleged to have pursued and eventually kidnapped Mbemo Nyando in connection with having witnessed the assault on Chief Albert Luthuli. Order number 3, it is it is ordered that a recommendation is hereby made that the Director of Public Prosecutions fully investigate the circumstances of the kidnapping or forced disappearance of Mbemo Nyando following his witnessing of the assault on Chief Albert Luthuli. And lastly, that it be recognized that the institutionalization of apartheid, which was already a crime in 1948 according to the international common law, and with respect to which the case of Chief Albert Luthuli was handled, is evident from the acts and omissions of members of the following government departments: A. Department of Health; B. The South African Police; C. South African Railways Department; and D. The Department of Justice. I must at this point, at the end of this grueling inquest, thank everybody involved here. Lieutenant Colonel State, thank you very much. Warrant Officer Sunet, thank you for being our Chief Luthuli for the time being in this simulation. And I must thank all the investigators, Warrant Officer Davis, for the reconstruction. It was very enlightening. I see you delighted and because I don't tell them I'm not here, but I thank them in absentia for providing us with their trade and for the valuable information. And most of all, thank you, Mr. Dimi, for leading your team so well. Ms. Chen, thank you for producing steady work. Mr. Nobel, thank you very much. I don't know why Mr. Nobel sits so distant away from me. Mr. Smart, thank you very much. And the museum, the team from the museum, Mr. Trucy, Mr. Gala, and thank you everybody that has the patience to come and sit and listen to us. Thank you, Mr. Jeffrey Kadero. Thank you, Professor Najima. Thank you. I can't mention everybody. Thank you, Ms. May here, Becky. Thank you very much. And thank you for Dr. I don't know whether she managed to make it. And also all the children and grandchildren of Chief Albert Luthuli. My secretary says, oh, okay, there are so many people to thank you. Let me take my choices. I see Mr. Spoon Level. Thank you very much. I think that finalizes my job. I will make sure that the copy of the judgment and the Annex A, which has the details of the time analysis, the distances of the train, measurement of the tonnage of the train, all the simulations that were done. We've got them on record, but I will get Mr. Junior in due course to provide that to the museum so that whoever wants to read more on this may do so. And I will request Mr. Jeffrey Kadere to provide those two books that he used in his testimony so that they also form a part of this record to be delivered to the prosecuting team for online transmission to the Luthuli Museum. Thank Mr. James.
So I will 1 second. I'm gonna go to the office now. It's fine.